Thank you, everyone. Welcome to our Research Connect series. My name is Angela Carpenter, a CDTRP PFD, and I will be facilitating today's webinar. I'm the Organ and Tissue Donation and Transplant Manager on Prince Edward Island for the Department of Health and Wellness. First, I would like to acknowledge that the CDTRP is hosted by the University of Alberta, which is located on Treaty 6 territory, a traditional gathering place for diverse Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Anishinaabe, Inuit, and many others whose histories, languages, and cultures continue to influence our vibrant community. I live and work on Ebikwit, which is PEI, located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. Ebikwit Mi'kma'ki is covered by the historic treaties of peace and friendship. We pay our respects to the Indigenous Mi'kmaq people who have occupied this island for over 12,000 years, past, present, and future. I encourage you to write your land acknowledgement in the chat box. We would also like to acknowledge AstraZeneca and CIHR, without whose generous support, we would not be able to host these sessions. Before we dive into the main content, I will pass it to Erica for some general CDTRP updates.
Thank you, Angela. Today I have one announcement for you all, and it's to save the date for our PFD forum. This year's Patient, Family, and Donor Research Forum will be held virtually on June 13th and 14th. Registration will be free and can be done through our website. The link to register will be live soon, so keep your eyes out for that. Thank you.
Thanks, Erica. Before I introduce the speaker, I have a few housekeeping notes. Today's session is recorded and posted on the CDTRP website and YouTube channel. During the presentation, please keep your mics off. If you have a question or comment, you can raise your hand with the raise hand button or type it in the comment section. I'm pleased to introduce our presenter, Dr. Eva Bruhova. Dr. Eva Bruhova is the Business Development Manager at Brock University. Her key role is to manage Brock's intellectual property portfolio and to advance industry research partnerships at Brock. For the past 5 years, Eva has been an integral part of the innovation and commercialization team, where she has helped researchers secure partnership grants, research contracts, and commercial licenses. Eva holds a PhD in computational biochemistry and a postdoctoral fellowship in biophysics. Eva enjoys fostering research partnerships and inventions that impact our community. Okay, Eva, I'll hand it over to you.
Thank you. Thanks for the nice introduction and inviting me to speak. I'm just going to first share my screen. Hopefully I've got this one correct. Yes. Can everyone see my screen? Please, if you have any questions, please, you're welcome to interrupt me, put up your hand or wait until the end of the presentation. I'll leave that up to you. So again, thanks for coming and listening to my presentation. It is basically a presentation about intellectual property and commercialization, and it's just an introduction to get you thinking about IP. Yes, my name is Eva Bruhova. Okay, and I'll start with a disclaimer that I will be only providing you with information, not formal advice, because every situation is a little different. Again, and then I am not a lawyer, so this is not legal advice. That's one thing I have to do before I start a presentation. Just an overview of some of the things that I'll go through is intellectual property, the different types, then IP ownership considerations, then like a neat 5-step model for the process of commercialization, and then questions at the end or again throughout the presentation. To get you thinking about IP, here I have I have a few IP myths to tell you about, and which includes actually one truth. So you can be sued for using a color. You can patent an idea. You can use any copyrighted work as long as you give credit. Registering your IP prevents others to copy your IP. So I'd like to, turn to the audience and spot the truth out of these three myths. Which one is the truth? So feel free to put it in the chat, like the number, which one you think is the truth. And I don't know where I have where's my chat?
I'm seeing a little bit of everything.
Okay.
4, 2, and 1.
Okay. 4, 2, and 1.
Yeah, there doesn't seem to be any consensus.
Okay. Well, no, again,
there's a 3 as well.
there's a 3 as well.
Yeah, 2
Okay,
1s,
good.
2 3s.
This is good. This is good. This is good sign that I've stumped you. All right. So actually the truth is you can be sued using a color. So the people that put a 1, good job. So here's an example. Cadbury, they have trademarked this specific color of purple for their chocolate wrapper. And no one is allowed to use this color in association with chocolate. Nestle actually, they started selling a chocolate bar called Wonka bar, and it was also purple. And it was very similar to this purple color. And they did get sued for infringing Cadbury's trademark. A similar example is Tiffany's Blue. That's another trademark for a color. So if you're a jeweler, you cannot use this blue for your business in association of your business. So yes, businesses, they trademark colors. So as for the other 3 myths, so you actually cannot patent just an idea. It must be actually a useful idea, and you need to back it up with data. So it's not just like an abstract idea. You need to back it up, and it needs to be useful. So again, some of these might be tricky, but again, to keep you thinking. Then you cannot use copyrighted work. The creator of the copyright decides how others can or cannot use their work. And then by registering your IP, you actually gain exclusive rights for your creation and the right to stop anyone else from, using it, selling it, using it or selling or making money off of it. So actually others can copy your IP, but you are the one that will need to actually monitor your marketplace. And then if you see someone copying your stuff, then you have the right to sue them, but you have to take them to the court and take on the legal action. So it's not automatic. You say, oh, this person's copying my work, or it's not automatic. You have to go and sue them. So think about you sometimes go to I don't know, the corner of a market and you see these Gucci bags. Are they really Gucci bags? So yeah, they can be copied, but you have to be the one policing them and then suing. All right. So I'll start my presentation talking about IP and what is actually intellectual property. Intellectual property refers to the creations of the mind. And according to World Intellectual Property Organization, these creations of the mind could be an invention, literally, and artistic works, designs, symbols, names, images used in commerce. So these creations are considered as property. It is something valuable and thus worth protecting. So really, when you talk about IP, quite often you talk about the protection of it. And here is a list of variety of protections of IP: patent, trademark, geographical indicators, plant breeders' rights, etc. It's not an exhaustive list. The 5 that I will concentrate are the ones that are most common in terms of IP, and the patent, trademark, copyright, industrial design, and trade secrets. So patents, they are a formal protection for inventions. An invention is any new or useful art, process, machine, manufacture, or composition of matter, or an improvement of these things. But an invention, actually, it must have these 3 things. It needs to be new, useful, and inventive. New, again, it has to be first in the world. There's no prior public disclosure or release of this IP. Otherwise, it wouldn't be new. Quite often we see people might, accidentally publish or go to have a presentation about their invention and release it to the public. Like if I was going to tell my idea right now, then and I can't patent it afterwards because I've released it out into the public. So we quite often warn people about that. Then it needs to be useful. Again, it needs to be operational, functional. You have to have some sort of backup data with it. And then also it has to be inventive, non-obvious. It needs to show like that you used a creativity beyond that would be obvious to someone of average skill in the same field, in that field. So once you file a patent, it becomes a public record, and it has a limited term of 20 years from the date of filing. It's also tied to a specific geographic area. So, you can patent it in Canada, and then your IP is protected in Canada, or in Japan, or in Brazil, or the US. But they'll all be separate patent filings. So if you think about that, it can start getting expensive if you file multiple patents. So, patents can cost anywhere from, a cheap one, probably 10,000, a more expensive one, 100,000. It also takes several years for actually patents to be granted. So, again, you have to think about, is patent worth it, the investment to protect it? Will you make enough money, to cover those patent expenses? And do you need to protect it in all these countries, or just where a market is large? But those are just, I guess, some questions that you run into before getting your invention patented. All right, the next thing is trademarks. Trademarks are everywhere where I look. You can see trademarks. It's basically a protection for brand identifiers. They only have a value used in association with a specific type of good or service. For example, like the red N, that's in association with Netflix. So again, there's a variety of ways how you can trademark your brand, and it could be in the form of a name, logo, shape. And increasingly, we even see other things like the sound, the scents, the colors, Tiffany blue, textures, tastes, etc., or even a combination of these. Patent, sorry, I keep saying patent, sorry about that. Trademark has a 10-year renewable term. The key phrase is use it or lose it. You must actively use it for the goods and services that you are, trademarked. Otherwise, actually, you might jeopardize your ownership. So it's, if you trademark something and then you don't use it, again, you could lose it. Trademarks you can actually adopt if you have a trademark for, a longer period of time, or you can get it registered. Copyrights. Copyrights provide protection for literary, dramatic, musical, and artistic works. So books, paintings, photographs, even software code. Other things are, yes, sound recordings, public performances, plays. And an important piece about that is a copyright protects the expression of an idea, not the idea itself. So that's just something you have to be careful, but you could write down your idea, the words, how it is presented there. You protect your copyright, the words in that particular order, but not the idea itself. Yes, then I just forgot to mention it's that C with the circle. So a copyright exists actually as soon as it is created and fixed in some sort of material form. Registration is not mandatory because of that, because it's automatically, but it can help you, enforce your rights in case you believe that your work has been infringed or might be copied. Copyright lasts for the lifetime of the creator, but afterwards it eventually enters the public domain. So for example, this year, the 1928 version of Mickey Mouse entered into the public domain. So anyone now can copy and reproduce this version without getting permission from Disney. But mind you, then Disney has copyrighted the other different types of Mickey Mouse, and they are still under copyright. Okay, the next thing I'm talking about, tell you about are industrial designs. That is for the protection of a particular shape, configuration, pattern, ornament, or any combination. Like I, for example, have here a chair. It's still a chair. The purpose is for sitting, it's a chair, but it has this unique shape that can be protected as an industrial design. Another example of an industrial design is our cars and how they've got the different shapes. Think about like a Porsche or a Ferrari. Again, that is an industrial design. So it appeals to and judged solely by the eye. Again, it doesn't necessarily have a particular function. And protections last for 10 to 15 years. Then the last IP that I wanted to tell you about, the last big one, is our trade secrets. And that is the protection of valuable commercial information, which has to be kept or has been kept confidential or secret to protect it. For example, the KFC recipe or the Coca-Cola recipe, those are trade secrets. Again, trade secrets can be new technology, new designs, recipes, and even data. Again, as long as you can keep it confidential. So the benefit of a trade secret is you don't have to actually formally register it, but you need to make sure that it stays confidential, and it can last forever if you keep it as a secret. Okay, so again, here's another question to the audience. Given what you've just learned, what IP protection could be associated with a smartwatch? So I'm just looking, what sort of IP could that be? Angela, could you actually let me know if there's anyone typing in the box? What are your thoughts? Again, I don't see what's happening in the chat for some reason.
Vanessa says industrial design. And then
Yes.
there's patent, industrial.
Good, good, good.
So industrial design seems to be the most popular.
Yes. So actually, the answer is yes to both. It has a unique shape. It has an industrial design. So actually, that was my first one that I have there. But there's actually multiple IP that is associated with the smartwatch. It has a unique and novel functions. So there's probably multiple patents protecting it. Then brand name or logo of, you know, the Apple Watch or any sort of company that has it, it would be their trademark. And then even if when they do some sort of like marketing campaign, then that would be a copyright. So there's, or even the software within it. So there's multiple IP associated even with just one piece of technology. So you were all right. Good. So the next thing is I want to talk about IP ownership because quite often that is a question, very common question. Who owns my IP? You know, I've created something, who owns it? And it's not really a straightforward answer. You know, it depends on multiple factors, whether it's just one or multiple creators, inventors, or whether you know it was created during your employment, and then even what's your organization's IP policy. So again, if you've you know developed this IP. And you know, you created it on your spare time or in your garage, you are the only creator, then it's pretty straightforward. You are probably most likely the sole creator owner of that IP. If you created it, I need a click. If you created it with someone else or multiple people, it can start get complicated. You might need to put some sort of agreements in place, like, you know, who did what and, you know, what percentage and how are you going to move forward with this IP? So it's starting to get complicated. And then did you create it, this IP part of your employment contract? So there might be some sort of contractual obligations. It's good to check what's in your employment contract. If you were told to create this, then it's most likely, and you were paid to do it, it most likely might be with your employer. I'll give you an example. I work for Brock University, and I've created this this presentation, which is actually, you know, it could be protected through copyright. And as I created it, you know, it's my presentation, my copyright. But I'm employed by Brock, and in my employment contract, all my IPs is owned by Brock. So actually this presentation is owned by Brock. Then also your institution's IP policy. Many of you may be working for hospitals or universities or some other larger organizations. Then it's good to know what is the IP policy. Some of them might be inventor owned. So if you're a student, for example, at Brock, if you're a student, you create IP, then it's actually your own IP. We're an inventor owned institution. But other universities, then whatever IP you create is actually institution owns, or quite often many for-profit businesses have like the organization owned IP policy. So it's good to check that out. So here's just actually a list of the key considerations. It's good to keep records of, you know, when you do have the idea, you know, to write it down or date it, sometimes lab notebooks or just any sort of files. Keep records of your idea. So again, if there's multiple creators, you know what you've actually created. It's not always easy to keep records, but it's a good idea. Then again, once you've done it, then it might be a good idea to secure your IP rights. Then look into your employment contract, or are there any sort of other IP agreements in place? Good to know about that. And then also, comply with IP laws. So be careful you're not the one stealing other people's IP. And I don't mean it, sometimes it's unintentional, but you just, again, have to be aware of that, you just make sure that someone's not already done that and you're taking their idea. All right, then the next section I wanted to talk to you about commercialization. So you might have an idea, how do you, get it out? And actually, this is going to be a commercialization with an asterisk, because I will go through a model, how you can commercialize your idea, but it can be applied beyond commercialization. There are other impacts. So in very broad terms, commercialization is a process to translate your idea into impact. And it doesn't necessarily have to be it doesn't necessarily have to be to make money. It can be academic, like papers, publications, presentations, or even student experiences. Societal, sustainability, environmentally friendly, you improve quality of life. Economic, create jobs, grow business, give back to the community. Then financial, yes, that is to make money. It is an impact. Or even to improve your reputation, that is an impact. So, so how do we get from idea to impact? It's a process that can be quite longer and can be complicated. But I've summarized it into like a 5-step innovation model to help you guide your idea. So it's basically a series of questions that it contains, this model. What's your problem? What's your solution? Who's your customer? How are you going to impact? What type of impact you're going for? And then how are you going to get there? What is the path to it? And I'm going to I will go through this 5-step model using an example that is actually was invented at Brock. So it's, research based on Brock's researcher. And it's about long nodules. So hopefully, this is a relevant case to this audience. So when a patient gets an X-ray or a CT scan of their lungs, there's these lung nodules or these spots that appear on the X-ray. And these lung nodules commonly, again, they are benign, but sometimes they are cancerous. So, to properly identify them, they need to be biopsied, which again, it's very painful, invasive procedure. And potentially every of these spots could be cancer, but it might not be. Again, commonly it might not be. So do we go into a patient and do we do biopsy of all these spots? And then, it comes out, a false negative. False positive. So, is there a better way that we can do that? So that's an example. And so let's go through the model. So problem, what's the problem? What are we solving? Have you identified the problem? What is the unmet need? So really, it's good to, again, identify it. What do people need? Or does your customer need? In our case, the problem was really lung cancer. Can cancerous lung nodules be better identified? Can we reduce the number of unnecessary biopsies? You know, filter out those false positives. So we need diagnoses that, you know, you can get your results sooner or better. For again to diagnose lung cancer. So now solution. What is the unique solution that you have come up with? It's, you know, how is this being actually solved right now? Like there could be some people that are, or companies that are trying to solve it now. But is your solution better, better than your competitor? And, you know, is new IP being created? So those are considerations. Again, how do you compare to what's out there? In our case, the solution was actually in this publication where they published, our Brock researcher published a set of cancer predictors to determine the probability that the detected lung nodule is cancerous. So it was like an algorithm of how to predict cancerous lung nodules. So who's your customer in that you're going to help or provide this service or this product? Who will benefit from your idea, and then who will use your idea? And mind you that again, you might think, oh, but that's the same thing. But no, sometimes there is a difference between who will actually benefit from your idea and then who will use it, and then who you will sell this idea to. And actually my example is the perfect example that it's not always the same receptor or the same customer. So in our case, patients, people at a risk of lung cancer are the ones that would benefit from this invention, this IP, and it would be to more accurately diagnose the risk. But who will use this IP? It would be actually radiologist or oncologist that would use it for their diagnosis. But really our customers are CT imaging software companies that they will then, license the IP from us. They will put it into their software. The oncologist will use it, and then it'll benefit people. So really the customer for us are these software companies. Then impact. What is the impact? What value can you bring to your customer? Why would they use this product versus, your competitors? Then other considerations it's to think about is what is the size and the value of the market? Like how many people will it benefit? And then even what's the potential revenue that you could receive from that invention. But again, impact can be academic, societal, economic, all those that I've mentioned. So it's, again, not necessarily just revenue. It could have a variety of impacts. So in our case, the researchers' IP translated into actually multiple impacts. We've got a more accurate diagnosis of lung cancer, fewer unnecessary procedures, improved patient care, better patient outcomes, a better quality of life. Then again, we got a better product for the CT imaging companies, and then even revenue. And finally, path. So how do you get your idea to your customer? It's not necessarily a straightforward path, like, there's a lot more to it. How much will it cost? Where are you going to find this funding? Again, do you have freedom to operate? What are the risks, the regulations, regulatory considerations? Then who's your team? Who will lead the process? And of course, your IP strategy. So in our case, actually, this was outside of the top 5 IP protection types. It was since our IP was a mathematical algorithm, it can't be patented because that's one of the outliers of patents. You can't patent a mathematical algorithm. So instead, we categorize this as know-how. Again, we are the ones to know how to do it. We licensed the algorithm to actually several CT imaging companies who then brought the idea to market. So they were doing then like the rest of the commercialization. So there you have it. These are the 5-step model for commercialization, from idea to impact. And I will leave you with some homework, something for you to consider. So think about, your idea that you have, and then answer these 3 questions. What problem does your idea address? What is your unique solution? Keyword unique. And then who is the receptor or your customer to this? And again, your idea doesn't necessarily have to be a commercial product. It's beyond just the product. There could be other impacts involved. So yeah, think about that, your homework. Yeah, that's it for my presentation, and happy to answer any questions.
Thank you, Eva. That was an excellent presentation.
Thank you.
Definitely things that I have never thought about before, especially the color thing. Although it's true, Tiffany blue is Tiffany's, not so much the chocolate. I don't associate purple with chocolate, but so I would like to ask the first question. If you have a trade secret, you said that you can't register that or trademark that. So like for the Kentucky Fried Chicken recipe, for example, more than one person knows that. So how do you keep other people from telling the trade secret? Is it just a non-disclosure agreement or?
Yes,
Okay.
That's basically it. A non-disclosure agreement. And again, if you leak your that information out, you could be sued. It's a non-disclosure agreement. Other ways how you can protect that, again, let only a few people know of this trade secret. Yeah, I believe maybe like the Kentucky Fried Chicken or the Coca-Cola one, but don't quote me on that. They again, there's a limited amount of people that know like the full recipe, or maybe just half. It's yeah.
That's
but
a good way to do it.
yeah. Again, it's worth a lot of money. So no, very good question.
And just gonna see. I don't see any hands up. What's in the chat?
My hand up. I have a question, please.
Okay.
Sure.
Great. Thank you so much for this talk. I thought it was super informative, and I really liked the interactive parts. That was quite fun.
Thanks.
Let us connect with each other a little bit. My question is, what advice do you have for researchers in the aspect that in the research world, they're so used to publish your paper, give presentations, give talks. And if by doing that, they could be doing themselves a disservice for something that they may not even know could be commercialized, what are things that they should keep in mind, and how would they work towards commercialization of something, but still also maintain their like academic priorities? that question makes sense.
Yeah, absolutely. Again, another really good question. That's always a tricky part. The best thing is, like, again, if you're planning to publish something and like you see there is some sort of value that someone could really benefit from this, apply this idea. This idea can make money. It is a good idea then to protect it before the publication. And to do that, like, you can submit again at Brock. They would work with me or our team. Before they publish, we could submit a patent provisional, and that's just like kind of to put your stake in the ground and say, okay, this is my idea. I'm putting a stake in the ground. This is my idea, and I'm going to protect it. And then you have a year to file the full patent. But again, it's good to really, again, I would say patent provisional would be again for the publication, if it's something to do with research. But I just wanted, sorry, just to mention again, not every idea is worth patenting. Go
So
ahead.
how would you know if an idea is worth it or not? Like, would you advise every researcher before every publication to check with their institutional's offices for guidance, or is there a good way of knowing what's worth it and what's not?
Again, being in that field, I guess you should generally, you might have an idea. I would imagine you would have an idea. And if you do not, if you want some sort of guidance, then come. I would like the researchers to come to me and check in before they're publishing. It's we can then what we can do some sort of market research and again look what's the market size, who actually this whole model we would go through that. And but again, sometimes it's a lot of work to get all these answers, so we would look into it. Sometimes there are certain improvements that they could make to make it better, so it is worth commercialization and worth protecting. Sometimes even delaying the publication by a few months could be again helpful. Or again, once you file that provisional, then you have that stake in the ground.
Thanks.
Did that help? Yeah.
Yeah, it is helpful.
Okay, Erica, I see your hand up.
Yes, thank you. Very interesting presentation. I have 3 questions. So on social media, we see a lot of like copycat recipes for trademarks. I'm assuming that's complete lies.
The recipes, like for...
Yeah, like you see a lot on specifically Instagram and stuff. It's like copycat Starbucks lemon poppy seed loaf. If this is a trade secret, I'm assuming this is like nonsense.
So I don't know if trade secret is. It's like again, you can copy like the KFC recipe, but you're not going to get it the right way they're doing it. And there could be sometimes even like certain processes they do, or again, you could try to do it, but you can back engineer in a way. Yes.
Going back to the color question, what if your logo has like 2 colors or like a gradient? Can you copyright a gradient of colors?
Probably. I'm not really sure.
Okay.
I've always encountered just the one, but again, it could be, it could be, again, if it could be even like the name of it, the different font and the colors. Yes. I would say yes, but don't quote me on that one.
My last one is, you saying they can sue you. What are they suing you for? We're talking huge numbers of money, or we're talking like something quite small? And you mentioned getting sued, I believe, in your first 2 points too.
Yeah. So again, if you're making money on selling these, fake Gucci bags, and you made some sort of money on it, then you're probably gonna have to, whatever you have made money on, you would have to give them. the money, but also probably some extra damage, their legal costs. So again, it can add up. It can add up. I can't tell you a number, but it can for sure add up.
Thank you.
Vanessa, you have a question?
Yeah, it's more of a comment than a question. I just wanted to thank Eva for being here today, for accepting this invite. I met Eva here at Brock, and mostly because of one problem that I had, and it started a whole discussion. I had one of my papers plagiarized, and then from there, I was trying to find ways of protecting my intellectual property, because when you get your work plagiarized, the copies may not be the same, but there are different levels of plagiarism that people are not aware, like paraphrasing it. It's still your idea, it's still your work, but people paint it a bit differently and they get published and they use all your ideas, your work, poorly, but they do. So that's how Eva and I met here at Brock, and we have had discussions around it. And I thought it would be a good idea to bring this to CDTRP, because that's not something we learn in school. That's not something I learned when I did my master or my PhD. And it's something that we should be aware of, like how to protect our ideas, if there is any potential for commercialization or any knowledge translation activities that we want to do later on. Like, it's still our idea, and we need to be aware of how we should protect it and carry forward with research more responsibly in that sense. So I really wanted to thank you, Eva, for taking the time to be here with us today. Really, really, really appreciate it. Thank you.
Thanks. Thanks, Vanessa.
Yeah, very true, Vanessa. It's not something that we're taught anywhere. Selena, you have a question?
Thanks. This was a really good talk, Eva. There are three of us who work together on this call, so I think that probably speaks to something we've been noticing within our research network. So a couple of, comment and question. I think this was really helpful because we've had, so we're a national kidney research organization supporting, anywhere from 18 plus projects nationally, working with patient partners. And as folks have probably pointed out on this call, researchers aren't really trained in this area. And yet it's a reality for a lot of the interventions that we are developing to address different, elements of improving kidney care. So, we're looking at researchers developing algorithms, trying to post their information on, fillable forms online or templates. And, we're starting to get requests from folks outside Canada as well who want to use some of these resources. So my question to you would be, would you be willing to sort of be a point person for us to connect our researchers to you? Again, because this is an area for us, like Katie, Cynthia, and I, probably not the right people to answer the questions, but we can certainly point folks in the right direction. So would that be a viable avenue? And then the second question that we had for you is, would you be open to perhaps presenting to our group at some point? And this involves our researchers, coordinators, patient partners as well. I think these are great learning opportunities. And I think sometimes just planting the seed ahead of time and just laying the lay of the land, these are the realities, these are some considerations, I think would be super helpful.
Yeah, sure. I can definitely do another presentation. Though I do want to say to be contact person for IP for other people. Again, I work just for Brock, so it's more Brock researchers. There are other organizations that do provide IP information. I wanted to say advice, but information. like we've got even like the Canadian Intellectual Property Office, and there's a whole bunch of them, and I can't there's a whole bunch of abbreviations, and I maybe I can put that in the chat. I can look that up, or if Erica sends the slides, I can my slides to everybody that registered. I can send the link of where you could get IP. So there are like federal and provincial IP professionals that could give advice to other people. Yeah.
I think
Yeah,
that would
I
be
certainly
a
can do
great
that.
idea.
All right.
Any more questions? We still have a few minutes, so I'm going to ask one more. If you have an idea that you think is just an amazing idea and it's going to help a whole lot of people, and you don't want to patent it, like you don't want to make money off of it, could somebody else make money off of it? Like, should you still patent it so that other
Yes.
people don't take it?
Again, that's up to you and what your priorities are. If you want it to be then, if you don't want to patent it, you don't have to. But yes, then if you publish it out and put it out into the world, someone can make money off of it. So,
Yeah, that's too bad.
Yes.
I was thinking of, I think, is it Volvo that created the seatbelt?
Yeah, I'm not sure.
Yeah.
And then everyone else was using it or what?
Yeah, they didn't want to patent it. They thought it was such a great safety invention that, everyone should have access to this. But yeah, I can't remember if they did patent it and then just didn't charge anyone for it, or yeah. So I just wondered, because in health, there are so many things that could benefit so many people, but they're out of reach just because of the expense.
Mm-hmm. Very true.
And Diana put something in the chat. Sorry, I'm not super familiar with Zoom. Another potential resource is the Lab to Market program at Toronto Metropolitan University. So thank you, Diana.
Actually, that's
Okay.
from me. I'm not sure why it says Diana, but I'm not Diana.
Oh, okay. Lori.
I'm not sure why I'm labeled Diana, but that's not me. It's
Well,
so
thank you.
So this is a program that we're involved with because, specifically along the pathway that you described in your talk, which is so interesting because we had an idea of when Ann Halpin, one of my lab members, and I, and we've got IP on it now, and we're just learning all this speak about commercialization and protection and pathways to commercialization. And there's a program through NSERC that allowed us to liaise with this group at TMU called Lab to Market. And they're actually holding us by the hand and walking us as babes in the woods through this learning experience, which is, I have to say, quite painful because I'm not used to feeling entirely incompetent in front of a group of people when you know the content and the science, but you know nothing about what they're asking you about. Well, what's your value proposition and what's your blah, blah. And I'm like, So we're really learning a lot, and it's a really valuable program because they're there. They're really there. Their whole raison d'etre is to support the entrepreneur, not necessarily the product, the idea, but the process. And so I think for CDTRP, it might be useful because we have clearly a need for this to explore this further. Manuela sat in on our first meeting with them, and so Manuela, I think and Patricia did as well. So I think there are potentially useful opportunities to work with them. I'm not sure exactly how because we were brought in through an NSERC grant, but I think that could be really helpful. It resonates, Eva, with all the things you were talking about.
Oh, good. Yeah, I'm familiar with that program. We have a few researchers that have done that. Yeah, and graduate, it's like a researcher and graduate student combo. And then, yeah, they attend these sessions, and then really the graduate student then, or maybe even the researcher, does like the primary market research. So it is actually saying non-confidentially what your idea is, but maybe like very non-confidential summary. So you don't, release your details like your actual invention. But, you say, what's your opinion about this? And so you get their feedback, and they'll say, it's really good it's a great experience, especially for the students and probably even for faculty researchers.
Oh,
Yeah.
way beyond students. I mean, it's like,
Mhm.
as you've all said, where in our training, like Vanessa said, where in our training do we get this kind of training? Well, we don't. Actually, we don't. And I think there must be a real need for it out there, because this program and several others that people have talked about really, have been put forward because and maybe it's part of the recognized need in Canada to move things from the lab to the market. And I'm using lab loosely here, because we don't do it very well.
Yeah, Lori, you were right. The lab to market is a great place, and thanks, Eva, for your presentation. It was great. I took like lots of notes here that we will be using with this CDTRP, and yeah, it's great to think beyond our lab box, because as researchers, we think that our study is done once the manuscript is published. But no, there is a whole new place. There is the market, there is the commercialization, there is the putting on practice whatever we have developed. And it's important to talk about this. So thank you very much for your time and for sharing your knowledge.
Yeah, thanks. It's true. Again, in the lab, we've got the data, the experiments, or we're looking for these. We've got these questions, but actually, if we slightly modify the research, then you could actually people could be using it more. But you need to know their experience or their feedback. So yes, it's Lab to Market is a good program.
Okay. Thank you, everyone. I see that our time is up. It's 4 o'clock. Eva, that was amazing and so much information and so many questions. Great discussion, everybody. Thank you for your questions and comments through today's presentation. Dr. Bruhova, on behalf of CDTRP, thank you again for presenting. If anyone has additional questions, comments, or suggested topics and speakers, contact Erica Croft at ekcroft@cdtrp.ca. I want to mention that all participants will receive an email asking them to fill out a survey, and we would really appreciate it if you took 3 minutes to complete it. Thank you, everyone, and enjoy the rest of your day.
Thank you. Bye, guys.
Bye.